Okay. Any business I need to take up before I call for our jurors?
Your Honor, our first witness perhaps needs to be brought out. I'll let the court direct us. She is going to be brought out as opposed to walking in from in the back.
Okay.
So the court have us to bring her in after she's called.
How is she dressed?
In the attire provided to her by the state.
Okay. Your choice. If you like, we can bring her out right now and have her sit if she's wearing that, or sir.
Good afternoon, sir. Good afternoon, everyone.
Before you say anything, Mr. Steele, did you? No, don't go anywhere. Don't go anywhere. Did you offer her to be dressed in civilian clothing?
No, we just we did not. We let her. No.
Was that due to because she didn't want to, or is it because of?
There were circumstances. So she's our witness. We're fine. I'll speak louder.
Okay.
Your Honor, no, under the circumstances, we did not. And she is the state's witness, and we do not have a problem with her coming out. There's no problem with that.
I just wanted to ask. Now, Mr. Steele, I'm sorry.
Additionally, Your Honor, we have requested and we wanted to make certain that it is understood that her face is not to be filmed.
And why has she been threatened, or is that to prevent her from receiving additional threats? Because I assume that she's in custody. Is that correct?
That is correct.
Okay. All right, Mr. Steele. Now.
Good afternoon, sir.
Good afternoon, sir.
And good afternoon to everyone again. Mr. Ryan, I'm glad you're okay. I haven't said anything of substance. Your Honor.
Sir.
This is the first I heard about it, so I just want to inquire if we could have a minute with the state. There may be some impeachment information that we're entitled to under Brady with the prongs of impeachment as well as exculpatory. And and I know nothing about it, but if the witness is not going to say anything, I'd like to know that before the jury comes out. Or if she's going to invoke some amendment, privilege, I'd like to know that too, because it should not happen in front of a jury. Now, I have no basis. I'm just learning about this, but that's what I would like to find out.
Okay.
She failed to appear. She was picked up on a material witness warrant. That is why she is in custody. So there's no all of that going on. There are no outstanding charges. She did not appear. She was subpoenaed. She did not show. We had to find her.
I understand, but if there were any communications, I'd like to know. If there were any communications at all, like why didn't she appear? What was said? I mean, if you have that, we're entitled to it.
No. You can certainly, for the benefit of all counsel, indicate any conversations that you may have had with a witness prior, which caused you to, that would be, I guess, responsive to Mr. Steele's inquiry.
Okay. Your Honor, the witness has indicated from the beginning that she did not want to testify. When I met with her late last year with Chief Investigator Randolph with our office, we spoke, and she emphatically indicated she did not want to be involved. We told her that we had to, this is what we have to do. She indicated that Mr. Anderson, who is her child's father, was the way that she said, initially, she started off with, I blocked everything out from then. I blocked everything out. And I said, okay, you know, let me just start off with the fact that I'm sorry that all of this has happened to you. And then she said, I've been in a bad place. I went to prison. I learned my mother was sick, terminally ill while I was in prison. The year after I was released from prison, my mother died the day after my birthday. And there have been times when I didn't want to go on, but I have these 3 boys, so I have to go on. We talked about herself, her family. She indicated that when I spoke with her and said, you know, let me just say, I asked her whether anyone ever contacted her following the 2013 robbery by the defendant Williams and Mr. Murphy. She said no one had ever spoken with her, that we were the first ones that spoke with her about that. She said, I said to her, well, I suppose, and I was remembering differently than what the report read. I said, I suppose that's because the officer said that they called you and apologized and gave you your stuff back. She said, what officer said that? When did they give me my stuff back? I said, this is what I think I remember from the report. We had it seemed amicable kind of interaction. She agreed to meet with us again as time went on, if we needed to, when we needed to. Later, as it grew closer to the time that she needed to appear in court, she came here for court. Earlier this year, I went outside to talk with her again. I had reached out to her by various means between that time and the time I first met with her. When I sat down to talk with her, she said, I want to take my life, essentially. And I asked her, you know, what had happened, why? She said, you're making me feel that way. So I left. I walked away from her and called in an advocate and our lieutenants, our investigators were called. They then called an ambulance. She indicated that she did not need an ambulance. After needing her the next time, most recently, we were trying to reach her to appear on March the 26th. We reached out to her several times. She did not appear on March the 26th. One of our lieutenants reached out and said, we don't want to have to get a material witness warrant for you, but, you know, you have to answer our calls. We then came to, we secured a material witness warrant. In the meantime, after that had been secured, she texted our office and said that she was in the hospital, but we had eyes on her home. Her car didn't leave the driveway. So officers went into her home, went to her home and executed a material witness warrant for her arrest on yesterday. She was taken into custody yesterday. She was not happy. And as a result of that, Your Honor, I also wanted to bring to the court's attention, as far as what she will say when she comes in here, there is no privilege to be invoked. So I know she does not want to be in jail. She has made, I'll call them savory comments as to what can be done to her. She's not a fan of our office, and that's where we are. Additionally, Your Honor, as a result of all of those facts, I wanted to just point out, I don't know if she's going to be cooperative. I don't know if she's going to be hostile, but I've printed out for the court's consideration and copies for counsel of questions. I may have to ask her questions that are closed-ended. They will be maybe one-word answers or closed-ended questions, those have tended to garner objections. But I just have case law that says a question that requires a yes or no answer is not a leading question. A leading question is a question not suggesting the desired answer is not leading, where it inquires only into a single fact. That's Milner, M-I-L-N-E-R versus the state, 258 Georgia App 425. Wiggins versus the state, 338 Georgia App 273 is a 2016 case. The Wiggins is 338 Georgia App 273, which states a question is not open to the objection that it is leading when it does not suggest the answer desired. So the court found that questions such as, now, would she actually hold your hand during this time? And now, did he ever get his private part inside your vagina? That they did not suggest the answer desired. That the questions, in fact, did inquire into only a single fact, but because they did not suggest the answer desired, the questions were not leading. The court also cited cases wherein the question, was any money demanded of you, was argued as leading by an appellant. The court said that was not a leading question. And allowing a prosecutor to ask a 14-year-old witness, did you see the defendant with a gun, was also not a leading question. And as to that issue, the last case that the state has for the court's consideration is Burden, that's B-U-R-D-E-N versus the state, 332 Georgia App at 811. That's a 2015 case, which also says a question is not open to the objection that it is leading when it does not suggest the answer, but only inquires into a single fact. They cited Milner for that assertion on the court's part. So, Your Honor, I do anticipate asking closed-ended questions as opposed to more open-ended questions. But unless the witness proves herself hostile, we won't need to lead. If, however, she does prove herself hostile, the state is prepared to ask the court for permission to treat her as such. And we have the cases for that as well. And I would point the court's attention to ISA, spelled I-S-S-A, versus the state.
When was that decided?
2017.
There's some more recent cases. I thought Brown versus the state, 314 Georgia 193.
We have that as well.
Okay.
Thank you.
All right.
So we are not at this point asking that she be treated as a hostile.
We need to see what she says. And
right.
What comes up.
Issa, Your Honor, is.
That was Mr. Matthews.
I know. I was just addressing the court, but for his benefit, that was 340 Georgia App 327 at Penn Site 340.
All right. Thank you, madam.
You're welcome, Your Honor.
Yes, Mr. Steele. I'm sorry, Mr. Harvey.
Let me just comment for the record that we had a 1 o'clock start today. None of it was provided to us this morning or yesterday. So, I mean, it's pretty disingenuous to come in and start, hey, I'm speaking, to start citing cases and saying I can ask these questions after the state arrested somebody yesterday and holds them in jail, number one. Number two, everything that I heard that was stated to the state is Brady material. the person's mental state, what she said, the statement that was given, none of which we were given that I know of. So in number 3, I do object to the public not being able to see this witness under the authorities that we have already provided to the court and argued previously. So number 1, I don't think this witness should be shielded from the public. We have been provided with nothing to verify that she is in any particular danger that would overcome the Sixth Amendment openness provision of this particular trial. Number 2, I would like that Brady material and a chance to digest that with my co-counsel prior to this witness testifying. So I object on all of those bases.
Your Honor, if I may respond briefly to the assertion by Mr. Harvey that not showing her face on camera is a violation of their Sixth Amendment rights. This court has made these proceedings open to the public. The court streams these proceedings via Zoom down to another courtroom in this courthouse for anyone who chooses to see it. Anyone who desires to do so can come inside the courtroom by permission of the court, if the court allows, and can go into that other room. What the defendants do not have is the right to dictate where media, who is filming for the rest of the world, places its camera. The camera has been focused on defendants at various times, solely focused on defendants at various times during these proceedings. They have absolutely no right to dictate where the camera is pointed, and certainly not to tell this court what to allow or not to allow to be filmed in this courtroom. Also, Your Honor, on February the 6th, 2024, Mr. Uhelski provided to this honorable court and co-counsel as well as the media proposed orders on the state's limitation for recording, and indicated in that email that entry of the proposed order would not implicate, let alone infringe, any defendant's Sixth Amendment right. No constitutional provision guarantees a right to televise trials. The public trial guarantee of the Sixth Amendment, which reflects a concept fundamental to the administration of justice in this country, certainly does not require that television even be admitted into the courtroom. A public trial implies only that the court must be open to those who wish to come, sit in the available seats, conduct themselves with decorum, and observe the trial process. It does not give anyone a concomitant right to photograph, record, broadcast, or otherwise transmit the trial proceedings to those members of the public not present. That is Estes versus Texas, 381 U.S. 532 at Penn site 588 through 589. So, Your Honor, one, as it relates to an asserted Sixth Amendment right to have any witness have their face broadcast all over the world, there is no such right. And number 2, I disagree wholeheartedly with Mr. Harvey. We have provided this witness's name, information. Mr. Harvey has not made any indication whether he sought to speak with her. These statements that she made to me are very much more inculpatory rather than exculpatory. Brady is exculpatory. She never once even suggested that the defendants on trial, specifically Jeffery Williams, did not come to her house with Walter Murphy and his brother, while the defendant Williams' brother put a gun to her head. She said that I asked her whether or not the defendant Williams and her child's father, before this point in time, whether they were actually friends, whether they had been hanging out. She said yes. But she said, you know, she did not want to be involved in this. She is just like every other witness. There is no recording that we have received from this witness that we are obligated to turn over. The fact that we are having her brought out in handcuffs that I'm announcing to the court after her arrest yesterday, as well as counsel for the defendants, that this is the case, and just goes against, flies in the face of the assertion that there's something being withheld from the defendants.
All right. Anything else, Mr. Harvey, before I allow some of your other colleagues to?
Yes, I think the court has been provided with a number of authorities that defendants have a Sixth Amendment right to an open in public trial. That's not even debatable at this particular point in our jurisdiction.
Our cameras are in the courtroom at this point in time. The question is safety of the witness and the like.
Nothing, not a thing.
Well, I disagree with Mr. Harvey, so I'm going to overrule your objection. Do you have anything else, sir?
All right, well, for the record, I have not heard one factual basis, not a scintilla of evidence or a proffer that this person has been threatened or is in danger in any way that would overcome Mr. Nichols and all these gentlemen's Sixth Amendment rights.
Okay, sir. Thank you. Anything else?
Two, impeachment evidence is Brady. Someone who says, I don't remember something now, that's impeachment. A person who—
Did you seek to interview the witness? You had the witness's availability for almost 3 months. So you could have gone and interviewed the witness and gotten this particular evidence yourself.
That has nothing to do with whether the state has an obligation, a constitutional obligation, to provide everybody with exculpatory impeachment or giglio material under the United States Constitution, under the Constitution of the state of Georgia. And the fact that they interviewed them, this person, and that material is useful for impeachment, that is and falls under Brady. And so we're entitled to it. And we're entitled to it before the 1 o'clock when the witness is about to get on the stand in a jail uniform, which is the fault of the state, not us.
I don't think so, Mr. Harvey. That had the witness decided to just honor the subpoena, then a material witness warrant wouldn't be necessary. So that's a choice of the witness.
Your Honor,
Hold on. Let her finish, and then we'll go ahead.
Your Honor, additionally, when she was taken into custody, as I told the court, the witness, when I spoke to her, told us that I made her want to end herself. She accused us of harassing her, of harassing her. So there's that.
All right.
Anthony, just briefly.
Yes, absolutely.
I just want to point out to the court the order entered by this court related to the videoing of witnesses. The order that was entered by the court—
She's going to be videoed. She just won't be shown. They just asked that their face not be shown.
The order that Mr. Uhelski prepared and the court signed says that the witness or state may request that only audio of their testimony be recorded. In addition, for any specific alleged victims for whom there are legitimate security concerns that can be substantiated by the victim or the state, the victim or state may request limited identifying of the witness. So I'm not sure that there have been legitimate security concerns substantiated by the state.
Ms.
Your Honor, I will point out
Ms. Love.
that this witness is now in custody at the Fulton County Jail. We have endured weeks of testimony from a witness whose face was shown, who provided outbursts during court as a result of what happened when it was made public that he was coming in to testify, even when he chose to recall nothing. So we are, based on what has happened in this trial so far, in the interest of justice and in the interest of judicial economy, we are asking that for the sake of this witness, her well-being, her feelings of safety, that we not show her face.
Okay.
And Your Honor, I still do not hear legitimate security concerns that are particular to this witness.
Okay. All right. Thank you, Mr. Weinstein.
And just lastly,
Yes, Mr.
Huey,
Mr.
I would ask the court to require the state to proffer in specifics in terms of this particular witness.
I think that already just based on what Ms. Love said already and the court's viewing of what has gone on with the last several witnesses that have had their faces broadcast to the world, that there's a legitimate safety concern. So I'm going to overrule your objection. It's noted for the record.
And for the record, Your Honor, on that same note, the prior witness that came into court stated that his information had been broadcast. I didn't specifically.
He lost his job. He has been harassed. That's a security concern. Do you want you may want your phone number handed out because it's business to you, but for some people, he lost a job.
But losing your job is not a security concern, Your Honor. That's an employment concern.
Well,
Respectful.
I disagree. Given everything that this witness told us on the last witness who testified, the court will disagree with your analysis.
And I think that's a slippery slope, Your Honor, because now any witness, based upon the last witness, can come into court and state.
No, that's not true, Mr. Matthews. It's based upon what the witness endures on the stand and the collateral consequences to that. So I'm going to disagree with you respectfully. All right, Mr. Sharp.
Yes, Your Honor. So I agree with Mr. Harvey that Brady includes not only exculpatory material but also impeachment. But in the state's recitation of what occurred in their communications with Ms. Bennett, I heard several exculpatory statements or things that I deem exculpatory, that she has not been harassed or threatened by any individuals here, that she told the state that her significant other continued to associate with Mr. Jeffery Williams after she made these accusations. That she is.
I don't think that was said by the state or by the
she
witness.
accused the state of harassing her.
Yeah. Okay. That was.
And so these are exculpatory statements. These are impeachment. They fall under Brady. And Your Honor, I would ask, and I have something else after this, but I would ask that the state, I noticed Ms. Love said we don't have any recordings that we are obligated to hand over, which qualified her statement about recordings. I would ask that any recordings, any communications, any emails, any written statements by detectives, any notes that involve these episodes with Ms. Bennett and oral statements be reduced to writing that have anything to do with Ms. Bennett, because we are obligated to impeachment and exculpatory information. Additionally, Your Honor, I would ask that Your Honor, instead of calling the jury out to have the initial determination of where Ms. Bennett is and if she's a hostile witness or not, that we have a hearing outside the presence of the jury. I would ask that Ms. Bennett be provided legal counsel, because it appears that she may be under some legal jeopardy. She may have given false statements back then, and she's being brought in to testify now. And I would ask that she be provided legal counsel. She be allowed to communicate with legal counsel. And then we have a hearing outside of the presence of the jury to make some determinations before the jury hears from Ms. Bennett. Because I think there's a high chance of we're walking on thin ice with unknowns here. And of course, we're finding out about this for the first time.
Did you interview her as well? Did you seek to interview her?
I seek to everyone.
Did you seek to interview her, Mr. Sharp? Yes or no?
Your Honor, I know.
Did you seek to interview her? Yes, you personally, on behalf of your client.
Me personally, I have not.
Okay.
She has been interviewed.
All right.
So.
Okay. Anything else?
I don't do everything involved with my cases. There's investigators, there's other attorneys.
Okay, did you have an investigator go and seek to find her?
Personally? No, I didn't.
Okay, all right. Have a seat. Anything else? Anything else?
No, that's it.
Okay, all right. Mr. Steele?
Thank you, Your Honor. I just would like you to consider this as well. So when I researched, I heard the former witness, Mr. Bean, his answer was consistently, I don't recall. Something that I don't remember, I don't recall.
Among other things.
That's pretty much, my memory was, I don't remember.
Okay, among other things. Yeah, I would concur that was a lot of what he said.
So I researched that to determine whether this is I understand hearsay, if a person doesn't recall, then you lay a foundation and you get in the prior inconsistent statement because, you know, whatever they said or prior statement. But under confrontation clause, it seemed to me, there's not all that much on it that I could find, but that the federal courts and Georgia, one case in Georgia, has said that I don't recall, the person's not shutting down, so that satisfies the confrontation clause, but constitutional. So statutory is protected because I don't recall that lots of cases say you can impeach with the prior statements, you lay a foundation, and then the confrontation clause under the Georgia Constitution and the federal Constitution may, I don't want to concede it, but that's why I didn't object. The reason I bring this up to the honorable court, I have no idea what this next witness may or may not say, but if she truly shuts down, I just want you to know that that's why I don't want it to happen in front of a jury. I will be asking that nothing be said. You know, the prosecution cannot ask leading or non-leading questions, because if the answer is, I'm not answering, then it's a confrontation clause violation. That's why I wanted to bring it to your court. But when I heard this, that, you know, it progressed, but she's in custody. I knew something happened. That's why I asked Brady. We heard that then, and then, depending upon what she says, I just want to alert you, Your Honor, that there may be a confrontation clause violation, which, of course, you know, you asked us to tell you, which has to be harmless beyond a reasonable doubt. So it's the highest standard except for structural error. So I'm just letting you know, I have no idea what she's going to say, but it might be best practice to just ask her outside the presence of a jury, what's your intention? And if she says, I'm not here, I'm not talking with anybody, it's a dangerous thing to put in front of a jury. I'm just doing what you told me to do. So I'm making that confrontation clause argument now. I know it's not right because I have no clue. She might testify. But if she doesn't, I'm just letting you know that, you know, I'm going to be asking to approach and move for mistrial and strike.
Your Honor, I would ask Mr. Steele to, if there is case law that even suggests what he is saying, that he provide us with the cites, because my reading of the law is entirely contrary to the notion that he is proposing to the court, that what happened with Adrian Bean implicates confrontation rights. So I would also ask the court to inquire of Mr. Steele if he has any recordings of this next witness, if he had an opportunity to interview her, and what she told her, what this witness told Mr. Steele or any representative for Mr. Steele, since he is asking the court, because I don't know what strategy there is. I don't know if it has ever been, and I'm not suggesting that he did it. I don't know if someone told her, just don't say anything. I don't know, but I certainly would ask that the court not bring her in here outside the presence of the jury and ask her these questions and provide her an avenue. She has already indicated that she does not want to be here. For us to have to get a material witness warrant
She's a
for her.
reluctant witness. Does she
Right.
have any type of criminal charges or anything that would?
She does not have
pending?
her case happened in 2011, and she was sentenced as a first offender in 2014, I believe. And then that was in another jurisdiction. And then that was revoked when she got charges in Fulton. And all of that information has been turned over upon an open records request by Mr. Steele. So she was under sentence in 20. She was sentenced here in Fulton after she was revoked on the Clayton County charge. She is out of prison for that, and there are no pending charges against her. There's nothing, she doesn't have charges. Also, Your Honor, according to Allison, Allison versus the state 356 Georgia app, 256 at 258 through 261, the Court of Appeals has said in 2020 that a witness's inability or unwillingness to recall specifics in their testimony does not make them unavailable as a witness for purposes of hearsay and confrontation clause objections.
You're not conceding that.
I
You're not conceding that. You said that, yeah.
I said Mr. Bean testified. I don't recall. I said that's why I didn't object. I found one case in Georgia that said it's not confrontation clause. I told you it's definitely not hearsay. I mean, yeah, there's nothing to rebut. So anyway, I don't know. I shouldn't get frustrated.
No. I mean, do you have any other case law that would say it's a confrontation clause issue? Because Mr. Steele, it looks like right now we're possibly faced with a witness that's reluctant. Would be probably the best term.
The way I understand it is, it depends on how she acts.
Exactly.
So if she's, and I have no clue, if she sits up there, what's your name? I'm silent. Is your name this? Silent. That would be, in my opinion, a violation of the confrontation clause, because there's no opportunity to cross. Different than, I don't recall, that's a statutory right. And as I told you, in Georgia, there's a confrontation clause case that says it's not confrontation clause. So, it just depends on what she says.
But
That's
she's
why
here.
I'm
I mean,
trying to,
and I could, depending upon what she does say or not say, allow her to be treated as hostile, so that leading questions could be asked. She'll answer them. She may not answer any of them.
right.
I mean,
And
and then you still have the right to examine her. I mean, but she may not say anything. I mean, that's the other thing that may happen.
And that's my issue that I brought to the court. If truly nothing is spoken, then I have a violation of the confrontation clause on behalf of Mr. Williams, Mr. Matthews Jr., et al. have that. I'm just trying to raise it to the court.
Your Honor, in the interest of justice, I would ask the court to inquire of Mr. Steele if he has any information, any recordings of this witness, anything of that nature, that give him reason, or even if he doesn't give him reason, if he has any recordings, if he has any information, if he had the opportunity to
Did you interview the witness, Mr. Steele? Did you have the opportunity to do that at some point in time? Because that does factor into whether or not, part of my analysis as to whether or not there's any other information.
Your Honor, I don't have to answer that question, but I don't mind answering ex parte on a sealed record, and the defense can come, but not the public and not the prosecution. So if we could go into your chambers, or everyone not with the prosecution, not with the defense, be excluded, and not with the court staff, not staff, the court's chambers, then I don't mind sharing the court.
I'm not asking for anything that's privileged. I'm asking for an inquiry into whether or not he had the opportunity to interview her and whether or not he made any recordings. I'm not asking for the content of those recordings, if he wants to call it work product or whatever. But I'm asking, in the interest of fairness, they are making assertions, assumptions, and all sorts of requests of the court. I'd ask that the court simply inquire, one, whether Mr. Steele interviewed her, interacted with her in any way, and two, if he has any recordings. Whether or not the state is privy to those is an entirely different other matter that I'm not even reaching right now.
Your Honor, I'm not, I'll do exactly what I said, and your honorable court can listen, hear, view, read, whatever you want, but I'm not doing it in front of the state. I don't have to do that. And it's the same thing that Ms. Love did earlier. I don't have to do this, but I don't mind. There's no wrongdoing here.
And Your Honor, if they're not willing to do that, then we're just ready to follow.
But we can't make these assertions, not do it with the court.
Because we'd rather not delay the process.
All right, folks, please, let's not do that. Let's not get into any of that. All right, give me a second, please.
Your Honor, may I just step out to use the bathroom?
Yes.
All right, it's clear we don't know what she's going to say. However, that's just the whether or not she testifies as to what, will be within her decision to do so and to testify truthfully. My concern, or the court's concern at this point in time, is that you, being the defense counsels in this case, may not have had the opportunity to talk with her about what she is going to say. I don't know whether or not my concern, as well as based upon the state's proffer of what they have said to her, is it may or may not be impeachment. It may or may not be Brady. But I think in order for you all to satisfy yourselves, you should be given the opportunity to talk with her. So I'll let you do that over the next 30 minutes. So you can talk with her and see what she says, and then we can kind of take it from there. Those who are interested in doing so. So that's the court's suggestion. So I'm going to be in recess.
Your Honor, I want to make sure she's sufficiently separated from the defendants. I know that she's going to come out over there, but I would ask.
I'll let Sergeant Ingram and his colleagues facilitate that issue.
Thank you.
Okay? Won't worry about that. I'll let him and his team resolve that. Okay?
Thank you.
Then, based upon what she tells you or doesn't tell you, I'll fashion or consider other things. But
And Your Honor, given that she does not have to speak with anyone, Your Honor.
But I'm going to give her the opportunity based upon what you've proffered. I really don't know whether or not anything that you have said to her would be exculpatory or would be impeachment. But I'm going to let them decide whether or not they want to inquire about that, because impeachment can be Brady. So, but I don't know. We don't have a good handle on what she's going to say. So I'm going to give them the opportunity to at least go ahead and do that. They've had the opportunity over the last 3 months. They've known who the witness is. They certainly, I believe that one counsel has probably interviewed her. And that might be Mr. Steele. The rest of them, I don't know whether or not they've done anything in that respect. But they have, and that's certainly something that they and their clients are going to have to take up. So based upon what you said, and just to make sure that there are not any, that they're authorized to determine whether or not, or anything that was said is of Brady or maybe of Brady, then I'll go ahead and do that this time.
Yes, Your Honor.
So, we'll be in recess about 30 minutes, see where we are. Sergeant Ingram, you and your team will facilitate having a conversation with, is it Miss Beverly? Bennett, Miss Bennett. Okay?
Yes, sir.
All right. Okay. All right. So we'll be in recess for 30 minutes. And counsel, so those of you that wish to talk to Miss Bennett, you can do so in just a minute. All right, where's Mr. Steele and Mr. Adams? West. What's her name? Yes. Thank you, ma'am. Appreciate it. All right, so our name is right back, sir.
Yes, sir. I just waiting on Mr. Matthews and Mr. Steele.
Okay, they're standing here. All right, thank you. All right, counsels, for those who have sought or had the desire to interview Ms. Bennett, are we complete with that? Oh,
Yes, Your Honor. Good afternoon to the court. Again, Carrington Matthews on behalf of Mr. Marquavius Huey. Your Honor, based upon my discussions with Ms. Bennett, I believe that the court likely needs to inquire upon her in terms of an appointment of an attorney. I believe that there could be some culpability issues that are going on with respect to some of the things that I learned from those discussions, and I believe that it would be in her best interest that she have an attorney.
such as, what did she tell you that would potentially inculpate her? Does it have anything to do with this case?
It does have things to do with this case, and I would have no issues with sharing that information ex parte with the court.
All right, come. Christy. Hold on.
Yes. Yes.
All right, councils, if we could go ahead and take our seats. Sergeant Ingram, can you go ahead and summon our jurors for us, please? Oh, I need to rule upon one other thing. I am going, oh, where's? Okay, hold on 1 second. All right.
Kendrick. That's it? I think so. Everybody's seated.
All right, Sergeant Ingram, are all our participants present, sir?
Yes, sir.
Okay. To the members of the media, if you would be so kind as to not place our next witness's facial video of her, you're welcome to audio tape and otherwise use any other medium at this point in time. Okay. Sergeant Ingram, summon our jurors for us, please. All right, ladies and gentlemen, please be seated. All right, Sergeant Ingram, all our participants. All right, thank you, sir. All right, ladies and gentlemen of the jury, good afternoon. Good afternoon. All right, again, like what has happened on a few occasions, took longer than we expected for our work outside your presence and hearing, so we'll continue at this point in time, and we thank you so much for your patience with us. All right, State, call your next witness.
The state calls Ms. Bennett to the stand.
All right, summon Ms. Bennett, please. All right, Ms. Bennett, if you could please approach the witness stand. Good afternoon. And before you sit down, turn and face Sergeant Ingram and be sworn as a witness, please.
Raise your right hand. Yes, your ability. You swear affirm the testimony you give today the truth, the whole truth, and nothing but the truth? Yes. Have a seat.
All right, Ms. Bennett, if you could pull yourself up as close as you can to the microphone and speak directly into it.
Thank you. Spell your last name for the court, sir. state and spell your first and last name for the court.
No, not person. It's the first initial.
Okay, what's your first initial, madam?
A.
And could you spell your last name for us?
Bennett.
All right, thank you.
And Your Honor, with the court's permission, as long as it's been in promises that nothing will happen if we do so, we'd like to have the cuffs removed from her. Send this over.
Yes.
May we have the cuffs removed from Ms. Bennett?
Yes, ma'am.
Good afternoon.
Ms. Bennett, you and I have had a chance to speak before you come into court. Is that right?
Yes, briefly.
And that was last year, before 2024 came. Is that right?
I'm going to check the
No.
legal question, Your Honor.
I'm gonna allow just a little bit, Mr. Adams.
Have we met more than once?
No.
Do you recall meeting with me and an investigator with our office in a Wendy's parking lot on Worland Avenue?
Yes.
And have we talked outside this courtroom in the hallway?
Briefly.
Briefly.
Yeah.
Okay. Now her mic just went out, Your Honor. Is it working? Okay. You said briefly?
Yes.
Now, let me start off by asking, do you want to be here today?
Objection, relevance.
I'll overrule the objection.
Go ahead.
You can answer the question, madam.
No.
Judge, I think there is something wrong with my mic.
Yeah, it may have a.
Oh, it's going in and out.
And go ahead. Do you want to be here today?
I
She hasn't
answered.
answered yet. I'll overrule the objection.
Answer it again.
You can answer it. Yes, ma'am.
No.
And are you here voluntarily or were you forced to come here?
I feel like I was forced to come here.
And Ms. Bennett, I apologize, but we had to have you come in and we had to have you.
Hold on. Mr. Matthews and then Mr. Adams. What's the? Oh, I'll sustain the objection.
Ms. Bennett, do you understand why you were calling here to court today?
Not really.
Ms. Bennett, did you grow up in Atlanta?
Yes, ma'am. Born and raised.
And what part of Atlanta did you grow up in?
When you say what part, like I lived in a lot of parts of Atlanta.
Say that again.
I lived in a lot of parts of Atlanta.
In 2013, Ms. Bennett, where did you live?
I'm Confederate.
Your Honor, excuse me.
Judge is going in and out.
Hold on. What's the basis for?
Part of the volume, I'm having a difficult time hearing the witness, the court was there asking the witness to remove the mask.
Judge, I think if I may, it literally, the sound is going in and out as she speaks.
Let me, Ms. Bennett, if you feel comfortable, do you mind taking off your mask? If you can, if you'd like to. I think we'd be able to probably hear you a little bit better. But that's up to you, madam.
It's
If you,
the audio, the
No.
behind your
No, I only got on the mask because within the last 7 days, my grandma, she just had COVID, and I just did my test, so they told me wear a mask.
Okay. All right. I think that answers that question, Mr. Adams.
Judge, I think it's the audio. It literally keeps going in and out from where I'm standing. So, Ms. Bennett, if you would talk loudly enough so that I could hear you without even having a microphone, can you do that for me?
I'm talking loud as I can.
Independency, Miss. I've got the same kind of issue with my mic. I don't think it's coming through it's kind of coming in and out. Let me make a phone call. Hey, can you have Aaron or somebody from tech come over and troubleshoot our speakers? Because they're not coming, sound seems to not be coming out of them. Then you do them right now. He needs to come over, okay? All right, thank you. Yeah, I think it is. All right, let's try as much as we can. My mic seems to be working. Let's try yours again, Miss Bennett.
Testing.
Good. All right. Don't touch nothing. Nobody. Nobody. What'd I tell you, Mr. Matthews? You don't touch nothing. All right, let's see if we can kind of get through this. All right, go ahead, madam.
Ms. Bennett, who, without giving names, just in relation to you, if anyone, who lived with you in 2013 on Confederate Avenue?
Repeat it again.
What relations, what relatives of yours live with you in 2013?
Oh, my kids and my kid's father.
How old were your kids in 2013? How old are they now?
Well, I have a son that was born in 2013,
And what month was your son born?
January.
So on Mother's Day 2013, you were the mother of 2 children.
Yes.
Now, how long had you lived at Confederate Avenue by the time 2013 came around?
I'm not sure.
Did you live in an apartment, a house, or something else?
Before I lived on Confederate.
On Confederate?
Apartment.
What was the name of those apartments?
Trust Street Village.
Ms. Bennett, I'm going to approach you and show you what has been marked as State's Exhibit 1 Alpha Alpha.
Have you already shown that to defense counsel, madam?
I have a copy for them.
All right.
They have been served previously.
All right. Well, let them take a look at it before you approach the witness.
Yes, Your Honor.
Okay.
And we did send to them the PowerPoint that has all of these exhibits in them. So I'm showing 1 Alpha Alpha Council. Your Honor, I will approach my court this information. Mr. Adams?
Yes.
Yeah, you can keep that.
Gotcha.
Okay. You may approach.
Thank you. Ms. Bennett, I'm showing you what has been labeled as State's Exhibit 1 Alpha Alpha. Do you recognize those apartments that are pictured in State's Exhibit 1 Alpha Alpha?
It's kind of look similar unless they did a little different work to it.
When you say this kind of looks similar, what do you mean?
Like the layout of the building kind of looks similar.
And now I'm going to show you what has been labeled as State's Exhibit 8, Alpha Alpha. Do you recognize State's Exhibit 8, Alpha Alpha?
It looked like a door.
Is it your testimony that you do not recognize it?
No,
That is not your testimony?
I just know it looked like a door.
Okay. Do you recognize State's Exhibit 13, Alpha Alpha?
No, ma'am.
What about 14, Alpha Alpha?
No, ma'am.
15, Alpha Alpha?
Is it something I'm supposed to be looking for in it so I can know what it is?
You're just supposed to tell the jury whether you recognize those photographs
Oh.
or the items depicted inside the photographs.
No, ma'am.
State's Exhibit 17, Alpha Alpha.
No, ma'am.
State's Exhibit 20, Alpha Alpha.
No, ma'am.
State's Exhibit 22, Alpha Alpha.
No, ma'am.
No, thank you. I'm going to take these back. Miss Bennett. How old were you on Mother's Day of 2013? Let me just ask you this. What year were you born?
86.
86? And were you working during that time outside the home?
I don't remember.
Were your parents, was your mother alive in 2013?
You had to ask me like that about my mother?
Ma'am.
Why you say, was she alive? Like,
Did you have
Overrule,
a
sir.
family? Did you have a family structure around you in 2013? Miss Bennett, Your Honor, could we? Miss Bennett, I'm going to move away from that, and I'm going to talk to you a little bit about the first time that you and I met, okay? Do you need a moment?
Ms. Bennett, just let us know when you're ready, okay?
I'm ready, but did she really have to do that, like, for real?
You're subject to examination, but just let us know whenever you feel you're ready to go forward, okay?
I'm ready, Judge. I talked to Ms. Love about my mom like that. That's a tragic situation for me. Like, I haven't talked about this. I haven't grieved about this.
Okay, all right. Go ahead, madam.
Ms. Bennett, I'm going to wait until you tell me that you're ready to move forward.
Come on, Ms. Love.
And I apologize for bringing that.
You ain't even got to apologize. I know you did it on purpose. It's all good.
Let me hold on 1 second, Ms. Lowe. Just 1 second. All right, Ms. Love, thank you, ma'am.
Thank you. Ms. Bennett, I'm going to ask you this question. Were your children and your children's father the only people who lived with you in 2013?
Yes.
And during that time, how far away from your mother did you live?
Approximately about 12 minutes.
Did you talk to her often?
Every day.
And on Mother's Day in 2013, did something happen to you that caused you to later make a report to the police?
Not that I recall.
You earlier said that, or referenced when you spoke to me, when you and I spoke the first time, did you tell me about some things that you had gone through?
Yes.
Did you tell me essentially that the state had let you down?
Mr. Short, I'm gonna overrule your objection.
Did you tell me essentially that the state had let you down in a number of ways?
No, when I talked to you, that's like the first time I talked to the state.
Right. And when you say the state, are you talking about the district attorney's office?
Or unless you stating like me being locked up and stuff, and I told you that, yeah.
Yes.
Yes. Yes.
And you spoke to me, or did you speak to me about giving some tragic information while you were locked up?
About when I was locked up? Yes.
And did that cause you to have any feelings of resentment towards the state?
Objection, Your Honor, leading.
I'll overrule the objection, Mr. Matthews. I'll make it a continuing objection. Overrule, sir.
You repeat it?
Did what happened to you have an effect on you and your feelings towards the state?
Yes.
How did they affect your feelings towards the state?
Also, make an objection on foundation.
Overrule, sir.
It just made me feel like, like they weren't trustworthy or something. Like a lot of things had happened.
I'm sorry that you were made to feel that way. When was it that you were...
I'm going to object and ask that that last statement from the state is stricken. That's inappropriate.
Yeah.
I'm gonna overrule the objection, Mr. Adams.
Ms. Bennett, when was it that you were locked up, as you just referenced? What year?
2013, 2015 to 2017.
In 2015, is that when you went to the Department of Corrections?
Yeah, I went to prison.
In 2013, were you in prison?
No, I was in Clayton. I think Clayton.
In 2013, were you out on bond for charges in Clayton?
I can't remember if it was Clayton or Fulton.
I'm going to show you what I will have marked as State's Exhibit number 28 Alpha Alpha. And I'll ask you to take a look at it. And I'll ask you if this copy of documents from Clayton County, Mr. Adams, you want to come to me? Refreshes your recollection. I just want us to be able to look at what we're showing.
All right.
Thank you.
You're welcome. You may approach the witness, ma'am.
Thank you, Judge. Ms. Bennett, I'm showing you a document from Clayton County that I've marked as State's Exhibit 28 Alpha Alpha. Would you look at this document on the page that I've labeled, or that is labeled accusation, and then look at the counts. Tell me.
She can't, parties can't hear you, Ms. Love.
Okay, thank you. Ms. Bennett, would you look at the document and tell me if it refreshes your memory as to whether or not your charges in 2013 were from Fulton or Clayton?
Ms. Bennett, let us take as long as you need to look at that document. When you're finished with it, let Ms. Love know, okay?
Okay.
Your Honor, the next document that I will show the witnesses is Exhibit 29 Alpha Alpha. I will allow defense counsel to look at that while allowing Ms. Bennett to look at 28 Alpha.
Yes, they say I was,
Don't read it out loud. Just let me know if it kind of refreshes your memory about the charges you were facing in 2013.
yes,
Were the charges that you were facing in 2013 out of Clayton County or Fulton County?
this right here is Clayton.
And did those charges happen? In other words, did whatever it was that led to those charges, did that happen in 2011?
No,
When did that happen?
this happened in 2013.
So were you out on bond for those charges on Mother's Day 2013?
I'm not sure.
On May 12th, 2013, Mother's Day, did you own a firearm?
What year this was?
2013.
In 2013. Yeah, I think I owned it maybe 2 firearms.
And what type of firearms did you own in 2013?
I really can't remember because I know the state, I think that's what you call it. They had one of my firearms in custody. I think I had to turn it in or something. Yeah, but I don't know which one.
Do you recall whether you owned a Kel-Tec pistol in 2013?
I'm not sure.
In Would you tell the jury the last name of your child's father that you lived with? Just the last name and first initial.
Anderson.
And what was the first initial?
M.
On Mother's Day, May 12, 2013, was your child's father friends with defendant Jeffery Williams?
I'm not sure. Was they friends or not?
Do you know who Jeffery Williams is?
Now I do.
What do you call him?
Thug.
What did you call him in 2013?
Thug.
Do you recall when we met that you told me that your child's father was friends with Jeffery Williams in 2013?
No, I didn't tell you what year. I told you that they did a video together, but I didn't know what year they did it.
Okay. And what video was it that they did together?
I don't know.
How do you know that they did a video together?
Because I seen it.
Were you there while it was made, or did you just see it on YouTube or something else?
Mm-hmm. I seen it on YouTube.
Okay. And do you recall what song or what it was that they talked about in the video?
No.
On May 12th, 2013, did you know a person called DK?
No.
Did you report to the police on May 13th, 2013, that you knew a person by the name of DK?
No.
Did you report to the police in 2013 on May 13th that you knew a person named Thug?
No.
Let me ask you this. You said you now know who Jeffery Williams is. Are you afraid of Jeffery Williams?
No, I know who he is. Because y'all told me.
Hold on, man. Hold on. All right. I haven't said anything yet.
Your Honor, I'm sorry, I was supposed to be able to hear this. We can't hear.
Yes, it is. He's behind you, Judge.
All this they doing is bench conference. You gotta remain in the back, so go ahead.
Seems like they're these things. They're not connected. All I'm doing is saying that. When you press the down like that. Hold on a second. I'm back in the box. Same time. You're doing the same thing. If you give me a minute, I can just maybe. I'm gonna have to take this one.
I'd share if I had more, but I don't have any. Yes. All right. That's affirmative.
I think we fixed that problem. Y'all got a problem with hearing now? Don't worry about him, he's deaf anyway. You know what it is, then we not gonna talk about it. Yeah, we good. We'll call you in a minute.
You may continue, Ms. Long.
Thank you, Your Honor. Ms. Bennett, do you recall going to the police station at Zone 3, the Zone 3 precinct, on May 13th of 2013?
No.
Do you recall how far the Zone 3 police precinct was from Trestle Tree, where you lived, on May 13, 2013?
No, I'm not sure how many minutes.
Say that for me.
I'm not sure how many minutes it is away.
Did you know where
10,
it was?
12, something.
10 or 12 minutes away?
Yeah.
And is that on foot or in a car or something else?
On foot, it's probably longer. Probably about a good 20-some minutes or something. Yeah.
And how was it, or how is it that you're familiar with where the Zone 3 precinct is, or was in 2013? Just tell the jury.
Say it again.
How are you familiar with where the Zone 3 precinct was in 2013, if you would just tell the jury?
The precinct is by the zoo.
And you had seen it with your own eyes?
I'm from Atlanta.
I'm gonna take that as a yes. Is that all right?
Yes.
Do you recall walking to that precinct on May 13, 2013, the day after Mother's Day?
I wouldn't have no reason to walk. I had a car.
What type of car did you have at that time?
A Porsche.
A Porsche?
Yes.
Do you recall taking your youngest child, the one that was born in 2013, with you to the Zone 3 precinct on May 13, 2013?
No, but you asking me this, the same thing that I'm saying no to.
Do you recall speaking with an investigator at the Zone 3 precinct on May 13, 2013? And I hear what you're saying, but I have to ask the questions, okay?
Well, I don't know how to answer the same thing over because you asking it in different ways, so I don't know.
Your Honor, Ms. Bennett, I understand what you're saying, but I still have to ask you the question.
No.
On May 13, 2013, do you recall riding in a car with your child and police investigators from the Zone 3 precinct?
Say it again.
Do you recall riding in a police car with your child from the Zone 3 precinct back to Trestle Tree?
No.
Do you recall telling the police that you were at home on Mother's Day at around 1 o'clock p.m.?
No.
Do you recall telling the police that on Mother's Day, May 12, 2013, you heard a knock at your door?
No.
Do you recall telling the police you asked who it was at your door after hearing a knock?
No.
Do you recall telling the police that you learned after asking that it was a friend of your child's father, known to you as Thug, who was at the door?
No.
Do you recall telling the police that you opened the door and let Thug inside your home?
No.
Did you ever say to the police that Thug's brother was also with him?
No.
And do you recall telling the police that you turned your back on Thug's brother, and a person you called DK after letting them in your home?
No.
Do you recall telling the police that you turned your back on them to walk into the kitchen to make your baby a bottle?
No.
Do you recall telling the police that when you went to the kitchen, Thug's brother put a silver 9mm to the back of your head?
No. And my baby didn't even drink bottles. My baby was breastfed. So no.
Did you tell the police that the two suspects, along that Thug, his brother, and DK demanded money from you and your gun?
No.
Did you report to the police that Thug, DK, and Thug's brother took your Versace necklace and approximately $100 off your kitchen table?
I never owned a Versace necklace.
Did you tell the police that they also took $4,000 and your rental car keys?
No, I thought you just said they took $100.
Off the table. And in addition to that, they took $4,000 from you and your rental car keys. Do you recall telling the police that?
No.
Do you recall telling the police that they placed your items inside a brown baby bag that also contained your red Dre headphones?
No.
Did you tell the police that DK took your Keltec model PLR 16 223 pistol?
No.
Did you tell the police that before leaving your apartment, DK fired a shot from your own gun into your living room wall?
No.
Did you tell the police that you waited for a long time before leaving the apartment after that happened?
No.
Did you tell the police that you stayed in a hotel for the night after being robbed by Thug, his brother, and DK?
No.
Did you tell the police that a neighbor told you that...
Objection to the hearsay.
Your Honor, we're not offering for the truth of the matter asserted. We're offering it for the impact on the listener, which was Ms. Bennett at the time.
That's already been ruled upon, Judge.
Your Honor, we are asking whether or not she told this to the police and whether she explained that as her reason for delay.
I'm on an overrule the objection. I'm gonna overrule the objection as to that, but this question is proper to be asked.
Did you tell the police that a neighbor informed you that they had returned around 4 a.m. and shot up your apartment, and that is why you came a day later?
No, it wouldn't make sense to come a day later if I was robbed.
Did you tell the police that you only went to the police after talking with your mother, who convinced you to do so?
No.
Did you tell the police that the phone that was stolen from you was a HTC Boost mobile phone?
I never owned a Boost mobile phone.
Did you tell the police that the phone number of that telephone that was stolen was 404-734-7358?
No, ma'am. The phone I have, I've been having the same number since, I think, 05 or 06.
Did you tell the police that Thug, DK, and Thug's brother were answering your stolen cellular phone with that phone number?
I don't think that'll make sense, no.
Did you tell the police that all three, Thug, his brother, and DK, were out with your child's father the night before?
No.
Did you tell the police that they left the scene in a blue Dodge Challenger and a brown four-door, possibly a Nissan?
No.
Did you show to the police the bullet holes in your apartment?
No. Police never came to my house.
Did you tell the police that you reported the incident the next day because you were afraid and you know Thug, DK, and Thug's brother?
No.
Did you tell the police that during the robbery, only one shot was fired?
No.
Did you tell the police that the one shot that was fired was into the living room wall behind your couch?
No, I thought you said it was somewhere else, but no.
Did you tell the police that the other holes in your wall were from when they later returned?
Wait, which part we talking about? Because it's confusing. You said I had one bullet hole, then now you're saying that I had some more. I don't understand what you're saying.
Did you report to the police that they shot up your home, according to your neighbors, at 4 a.m. on May 13th?
Yeah, my home was shot, but I never reported to the police that I did it.
Did you show to the police a picture of Thug and DK on your cellular phone that you did still have?
No.
Did you tell the police that they later called you and apologized for doing what they did? And by they, I mean Thug, DK, and Thug's brother.
You just said they had my phone. How they called me?
Ms. Bennett, did you have more than one phone on May 12, 2013?
I just said I've been having the same phone and phone number since like 2006.
Would you answer that question for me?
I don't understand.
I'm over the objection.
Did you ever have?
He said, did I ever have 2 cell phones? I said no already.
Okay. Did you have a Metro PCS cell phone?
I still have it.
And
Where y'all have it now?
what does that Metro PCS cell phone look like?
It's an iPhone.
It's an iPhone?
Yeah, ma'am.
What iPhone? What type?
Apple.
iPhone 1, 2, 3, 4, 5. Which one?
What I got? Probably 13, 14, something like that.
And is it your testimony that you had an iPhone 13 in 2013?
Did I have an iPhone 13 in 2013? My iPhone 13 was not in 2013.
Okay. So is it fair to say then that that cell phone, that Boost mobile cell phone that you had in 2013 is not the same one that you currently have today?
I didn't have Boost. Then you just said I had Metro. I've been with Metro since like 2005, 6 or something, and I've been having the same phone number.
But you didn't have the same phone, did you, in 2013 that you have today?
I'll stand.
Every year, iPhone
Hold on, Ms. Bennett. All right, I'm going to sustain the objection. You can rephrase.
Thank you, Judge. Did you have the same phone in 2013 that you have today with Metro PCS?
I couldn't have.
Did you have a Samsung phone with Metro PCS in 2013?
No, ma'am.
I'm showing you State's Exhibit 23 Alpha Alpha. And I'll ask you if you recognize the items depicted in State's Exhibit 23 Alpha Alpha.
What you mean?
Do you recognize what is pictured in State's Exhibit 23 Alpha Alpha?
Do I recognize the picture?
Do you recognize the items depicted in State's Exhibit 23 Alpha Alpha?
Oh, no.
Do you recognize the people depicted in 23 Alpha Alpha?
Objection, Your Honor's been asked
Yeah.
and answered.
Him?
I'm over.
Either one of them.
I'm over.
Yeah, him.
Hold on.
So,
And you're pointing to someone. You recognize one of the people in 23 Alpha Alpha?
you just asked
Hold
me.
on, Ms. Bennett. Let me rule upon the objection. I sustain this to form. You can just rephrase, madam.
Yes, Your Honor. Do you recognize at least one of the people in State's Exhibit 23 Alpha Alpha?
Yes.
Which one?
Thug.
Who?
Thug.
Okay. Do you recognize the hand that is depicted in State's Exhibit 23 Alpha Alpha?
A hand?
I'll show it to you again.
No.
How long have you known Thug?
I'm not sure.
Did you go to high school with him?
No.
Did you know him when you were in high school?
I'm pretty sure I'm older than him. I ain't go to high school with him, so he couldn't be in high school with me.
How old are you? I hate to ask a female, but how old are you? Would you please tell us your age?
I told you when I was born.
I know, but I need the record to reflect your words. How old are you now?
I'm 37 now.
And why are you so pretty sure that you're older than Thug?
I'm just pretty sure I am.
Why do you think that?
I'll allow it,
He
Mr.
seemed young.
Matthews.
He seemed younger than me.
Now you're nodding your head as you speak. What are you motioning towards when you said he seems younger than me?
He seemed younger than me.
Are you motioning towards anyone in particular?
You just asked me about a person. I told you that person seems younger than me.
Where is that person in the courtroom right now?
He's sitting over there.
What is he wearing?
I don't know. I can't really see him like that. Somebody there in front of him.
Who is he sitting next to? Describe the two people on either side of him.
A man with a brown suit and a man with a gray suit.
Is the man with the brown suit a black man?
Bless you.
Yeah, we talking about race now.
Okay. And the one with the gray suit, is he wearing a red tie?
Yes.
Your Honor, the record reflects that she has identified the defendant, Jeffery Williams, as the
It shall.
person to whom she is referring. And Ms. Bennett, is that the same person that you're referring to as Thug?
Yes.
Ms. Bennett, when you had charges in Clayton County, did you have charges with your child's father, Michael Anderson?
Yes.
And the charges that you had in Fulton County, were they also with your child's father?
I don't think so.
The charges that you had in Fulton County, are those the charges, or at least some of the charges that you said you went into the Department of Corrections for in 2017?
No, I got out in 2017. I ain't going in 2017. I told you I went in 2015.
Thank you for correcting me.
It's okay.
Are the charges in Fulton County the ones that you went to the Department of Corrections for in 2015?
Nah, Clayton.
Did you ever go to prison for the charges in Fulton County?
I think it was both.
So you went to prison for the charges in Fulton and in Clayton County when you went in 2015?
I think so.
Ms. Bennett, is it fair to say you never said anyone kicked your door down?
Have anyone ever kicked my door down?
I'm asking a different question. I apologize if it's not clear. Is it fair to say that you never reported that Thug kicked in your door on Mother's Day?
No, I never reported he kicked in my door. You said I reported that I opened my door. I can't open it in, he kick it. And it don't make sense.
And that's why I said, is it fair
Yeah.
to say that you never reported that he kicked in your door?
No.
And is it fair to say that you never reported that you were shot on May 12, 2013?
I never been shot. Unless y'all know something I don't know, because I ain't never been shot.
Ms. Bennett, thank you for being patient with us. If you give me just a moment, I'll have a few more questions. Okay?
Yeah.
Now, Ms. Bennett, when you met outside in the hallway, when you met with me outside in the hallway of this courthouse, were there investigators investigators and other people around.
Mm-hmm.
And at that time, earlier this year, did you indicate you did not wish to speak with me anymore?
No. Somebody told me I ain't had to speak with you no more.
And who was it that told you that?
Mr. Hamilton.
Did you tell me that I made you uncomfortable?
No, I ain't tell you that. Because I ain't speak with you.
Say that again.
I said I didn't speak with you, so I couldn't tell you that.
You're saying now that you did not speak with me outside in the hallway?
I'm sorry, can I have Mr. Love please speak into the microphone? Or speak up.
I'll speak up, Judge.
All right.
Are you saying to the jury that you did not speak with me in the hallway?
No, you asked me, did I speak with you? Was it other people around? I said yes. Then you said, did somebody ask you to not speak with you? I told you yes on that. Then you asked me, did I tell you? And I'm like, how am I tell you if I didn't speak with you?
Ms. Bennett, did you express at any point that I made you want to cause yourself harm?
No, it was more not, really not you, but the people in your circle, your team, or whatever they call. Because, like, yeah, I was really, like, trying to, I don't know, manipulate, if that's the word y'all was trying to do, or something.
What was it that I tried to manipulate?
Like the situation.
How did I try to manipulate the situation?
I don't know, like, I felt like you kept trying to, like, confuse me. Like, you trying to do the same thing now. You asked me, did I have a iPhone 13 in 2013 when you know an iPhone 13 wasn't out in 2013. Like, they drop iPhone, like, every year, but I thought it was out. Then you saying May the 13th, then you saying May the 12th, like, then you saying that somebody kicked my door, then you saying I opened the door, like, I don't know, like, I don't know which one y'all working, but you working it.
Ms. Bennett, do you understand that I can't testify and that anything that goes on the record for this jury to consider, you have to say it?
Mr. Sharp? It's commentary, Christina. I'll sustain the objection. You can just rephrase, madam.
Do you understand that only what you say is evidence and not what I say?
I don't know.
Okay. So do you understand that I have to ask you questions in order to have you answer for the jury?
I guess so.
And when you said that I was manipulating the situation, what situation is it that you're talking about?
I answered it.
Would you answer it again, please, for the record?
The one we talking about now?
I need you to be clear for the record, please. Which situation?
I don't know how
Hold
to
on,
answer.
Miss Bennett, hold on 1 second. I'm going to overrule your objection. Madam, you can answer the question.
I don't know how to answer what you want me to answer. Like, I'm thinking that I'm answering it, but probably not good enough to an extent, because I don't know. When I say situation, I don't know, like, because 1 minute you on this person, then you on that person, so I don't even know which situation got nothing to do with this situation. I don't know.
All right.
You know what I'm saying? Like, you're confusing me.
All right, let's be a little simpler. Did you just tell the jury that you felt I was trying to manipulate the situation?
Yes.
And what was the situation that you were speaking of? You have to say it for the jury. What was the situation that you're speaking of that you felt I was trying to manipulate?
And that's what I'm saying. Like, I'm answering the same question you asking me over and again. Like,
Ms. Bennett, Do you?
I don't know, because you spoke to me like on a lot of situations. Like you was talking about Thug, then you started talking about my kid's dad, then you was telling me, asking about my mom, like, but I don't think all those things went together. Like, I don't think all of them mattered with each other. So I don't understand.
Tell the jury what I talked to you about.
I thought I just did that.
What did I tell you, or what did I ask you about Thug?
You asked me, did he do a lot of things to me?
And
like
what,
you asked me, did he break in my house? Did he get this? Did he do that? Like all the questions you just asked. Like I can't remember all the questions you just asked. You ask them over, I can answer them.
all right. And do you recall what your answer was?
Yes.
Okay. What was your answer to me when I first met you in the Wendy's parking lot?
Yeah, you asked me, did I recall this person? And did he do these things to me? And I told you no.
What did you tell me? What else did you tell me?
Then we started talking about other situations. You was telling me about situations you had. And I think I started talking to you about my mama, which that's something I just told you. We ain't gonna do that here though.
Okay. Did you tell me that you had blocked out large gaps of time?
Yeah.
Okay. Did I tell you that an officer had stated that?
Your Honor, I'm going to object to number one, testifying, and number two, hearsay.
Your Honor, I'd ask that the court allow me to form a foundation for the question that will follow.
I'll sustain the question at this point in time.
Okay.
If you want to lay some more foundation, that's fine.
Do you recall me talking to you about Thug, DK, and Thug's brother giving you back your items?
They gave them back?
I'm asking you a question. Do you recall me talking to you about that?
I don't remember you saying that.
Do you recall me talking to you about them calling and apologizing to you?
No, I don't remember you saying that.
You don't remember that?
Mm-mm.
What else, if anything, do you recall talking to me about the first time that we met that you're comfortable talking about to the jury?
I repeat it because I just said it, but I repeat it again. When you talk to me about the situation with Thug. You asked me that I feel like he did any of those things, and I was like, no. And I know you did ask, was I scared of him? And I'm like, no, like I don't have a reason to be scared of anybody. And then you talked a little bit about yourself, and then we talked a little bit about the situation again. Like I said, you about to keep making me repeat myself about my mom, and I said I don't want to talk about that, and that's what we talked about.
Is it your testimony that you said that Thug did not do these things, or that you did not recall the year?
No, I told you he didn't do those things.
Okay.
And you asked me, did it happen in that year? And I told you I don't remember a lot within that year.
Okay. Did I ask you where you lived in 2013?
I think you did.
Did you tell me you couldn't remember?
No, I told you where I lived at.
That's your recollection, that you told me where you lived. Is that what you're saying?
Mm-hmm.
Basis. I sustain the objection.
And do you recall what the inside of your apartment looked like in Trestle Tree on May 13, 2013?
Oh,
You may answer.
I'm not sure because I know we had remodel. So, but I think that was 2012. I'm not sure. I don't want to be wrong.
Do you recall what your address was on May 13, 2013?
Mm-hmm.
What was it?
980 Confederate Avenue.
Was there a number or a letter?
Oh, D.
Just one moment, okay?
Cross. Mr. Adams, go ahead, sir. Whenever you're ready.
Ms. Bennett, good afternoon, ma'am.
Good afternoon.
I want you to do me a favor, okay?
Yes.
I'm going to ask you some questions, and if you can't hear me, or if you don't understand the questions, I want you to go ahead and make sure you let me know, okay?
Okay.
I'll be happy to repeat myself or to clear up whatever needs to be cleared up.
Yes, sir.
Clear?
Yes, sir.
All right. I want to start first by talking about you testifying here today.
Yes, sir.
Now, you've been brought in to testify,
Yes, sir.
and you've been brought here by the state. Is that correct?
Yes, sir.
All right. You didn't walk into this courtroom. You came out from. You're in custody right now.
Yes, sir.
You were placed into custody, and you're in the Fulton County Jail, and brought in here to testify. Correct?
Yes, sir.
Now, you were arrested on yesterday. Correct?
Yeah. Yes.
And you were arrested by who? The DA's office?
I know Mr. I just remember seeing Mr. Hamilton in Clayton County.
Okay. Mr. Hamilton is a DA's office investigator. Is that right?
Yes, sir.
All right. In fact, you had very many conversations with Mr. Hamilton. Isn't that right?
Your Honor,
Yes.
You have an objection, madam?
not at this time.
Okay, all right.
And you have also had conversations with other people in the DA's office about this case and about your testimony.
Objection, compound.
Sustained.
Okay.
You can rephrase.
I'll work it out. You have had conversations with other people in the DA's office. Is that true?
Objection, failed.
Yes.
As to others.
I sustained it as to question, as to vague.
Sure.
Just rephrase, sir.
Sure, absolutely. You have had conversations with Miss Adrienne Love from the DA's office. Is that true?
Yes, her and the other people too.
Right. You remember an investigator Long?
Yes.
Okay. So you've spoken over the course of the last few months with Adrienne Love, correct?
Yes.
You've spoken over the last number of months with an investigator Long, correct?
Yes.
You have spoken over the last number of months with an investigator Hamilton. True?
Yes.
Okay. Now, you have had an opportunity to discuss with them the things that you were asked about from 2013. Is that correct?
Yes.
Now, the first person, and I want to talk to you about how we go from your conversations with them to your testimony here today. Okay? Can I do that?
Yes.
Objection,
Okay.
Your Honor, as to the commentary, and we would ask that we.
I'm gonna overrule the objection because he's pointing to witnesses to what he wants to talk about, so I'll overrule at this point.
Yes, Your Honor.
All right.
Now, you understood from your first meeting with Investigator Long of the DA's office that they wanted you to come in and testify here in this case. Isn't that true?
Well, they was telling me that I didn't have to because he presented me with some paper that I didn't recall or I didn't know nothing about.
Okay. And you told that investigator that either you didn't recall or you didn't know anything about it. Isn't that true?
Objection.
Yes, sir.
As to statement.
I sustain the question. You can rephrase it.
Okay. Let me ask you this. Did there ever come a point where you were told by Investigator Hamilton of the DA's office that you did not and you should not talk to anyone but him?
Yes.
When did that happen?
I was here. It was like this month. I was here. I showed up. It was the same day I talked to Miss Long, and after the situation, they took me to him, and he told me I ain't need to talk to nobody else but him, like nobody. Period.
Mr. Adams, I hate to break you up at this point in time. I've had a bathroom request, so can we just take 5 minutes?
Sure, absolutely.
Okay, all right.
Absolutely.
All right, Ladies and gentlemen, we're going to go ahead and be in recess about 5 minutes. Please go ahead and take your respite, and then we'll come right back. All rise for our jury.
I'll try.
Lieutenant, hold on. All right, ladies and gentlemen, our jury has left us. Okay. Lieutenant, you may be seated. The rest of you need to take a comfort break and do so at this point in time. Please make it as soon as possible. All right?
Right there. Everybody see.
All right. Can we ask Ms. Bennett to return to the stand, please? Mr. Adams and Ms. Love, can I see you for a second?
Wes, is this pertaining to the case? The bench conferences? You need her to hold up, Judge? Put it back in there. Right at the door, Cap. We're coming out in a minute.
Okay.
Can we bring Ms. Bennett out now, please? All right, Ms. Bennett,
Yes.
can I talk with you for just a minute?
Yes.
Okay, all right. It is highly likely that your testimony is not going to be complete today. So what I like to do is to ask you and see if we could propose something else to you. Ordinarily, with a type of confinement that you're under, once you satisfy the testimony, you're released, okay? I'd like to be able to release you now since you're going to need to come back tomorrow. But I'd like to predicate that on if the state found you another place to stay this evening with appropriate supervision, meaning it would not be somebody that is not a female or to that extent, would you be willing, would you come back tomorrow morning?
I never had a problem with coming to court, sir.
Well, here's the challenge, and I'm not going to argue with you about anything. That was the reason why I had to sign the warrant. Okay, it's because it was postured to the court in an affidavit that you were not going to come. And I'm not getting into any of that reason. I'm not debating that. All I'm trying to do is to just to in the interest of fairness, because I don't want to jail you. I don't know. No court likes to jail any witness, okay? But it's a tool that we have to ensure compliance with folks that are less than, they don't want to come. That's it. So what I'm trying to do is, if you're willing to do that alternate arrangement where I'd sign an order to release you, I'll release you to the state, and the state will bring you back tomorrow morning, okay? That's the deal. If you tell me, Judge, I'm okay with that, then I will sign the order to that effect. If you're not saying, well, you know, if you release me, you can, you know, blank, 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 then I'm going to leave you where you are.
No, if you release me, sir, I don't have a problem coming to court. It was a reason I didn't come to court. If you knew what was going on or what was happening with the state, you don't know why I wasn't here.
And that's not for me to. And that's
I ain't finna lie to you. Like, I ain't gonna feel safe with being with them.
Well, you're going to be put up in probably a hotel is more than likely what will probably happen. Okay?
Okay.
That work for you?
Anything that I need to do for you, sir, I'm right here.
Okay, so you'll agree to that as opposed to 901 Wright Street?
Yes, sir.
Okay. All right. Then what I'll do is I'll sign an order to release you, okay?
Yes, sir.
Okay. And then you'll come back tomorrow morning. I'll need you to be here for 9 a.m. tomorrow morning. We'll resume your testimony. It is highly likely that you'll finish tomorrow, okay?
Yes, sir.
All right. Okay. Counsels, can we go ahead and just excuse her at this point in time? And we'll just tell the jury that we're recessing for the evening?
Yes, Your Honor. The court will give us an opportunity to draft up.
Yes.
We have no objection, Judge, but if we would like to address the court about something else related to that, we have an opportunity.
Does our witness need to be here for that or for, so we can excuse her? Okay, all right. Madam, I'm going to go ahead and excuse you, and we'll work on getting the order, so you should be released this evening, okay?
Yes, sir.
And then we'll see you tomorrow morning.
Yes, sir.
Okay? All right. Okay, thank you.
That's yours, right? I believe.
All right, counsels, our witness has left us. Mr. Adams, anything before I go ahead and bring our jurors in?
Yes, can I have just one moment, please?
Okay.
Yeah, and we can bring the jurors in and dismiss them, and then we can address the issues, so we won't hold the jurors up if that's okay.
I don't want to take that long. I'd like to go home, so. Okay, all right. Excuse me.
Yes, Judge.
Okay, Mr. Adams.
This probably, this actually should not really need saying, but I'd like the court to advise, remind, or make sure it's clear to the state that, of course, this is a witness that is in the process in the middle of her testimony, and that no one from the state whose care she will be in this evening, to some extent, is to have any sort of communication with her about the testimony, or talk to her about the testimony, or anything whatsoever. That's the first request. If the court is amenable to that, that may be the only.
All right. State, do you have any issues with that as a standard admonition? Okay, so, all right.
All right. Second thing, actually, the second. I think at the bench, I heard the prosecutor indicate that Ms. Bennett would be in the care of female investigator this evening in terms of making those arrangements.
I heard that as well.
Your Honor, I don't mean to interrupt Mr. Adams, pardon me. But, Your Honor, I was just speaking with our chief investigator, and regarding, Your Honor, I don't know, I don't want to jeopardize her appearance tomorrow, but he had asked me whether the court was amenable to, if she gives the court assurances that she will return, whether the court is amenable to allowing her to go to her home.
That's not what I told you to do.
I know.
Okay, and which investigator asked you to do that? Who asked you to do that? Was it Long? Come on, tell me the truth. Don't lie to me. Come on now. No, I'm trying to protect everybody. No, I did. That was not the deal. Okay. So, anyways, okay, all right, Mr. Adams.
It's really simple. I mean, there are female investigators in the DA's office.
Sure.
Based on her comfort, what I think would be appropriate. I'm asking the DA to make sure that she's in the custody care of a female.
Well, Your Honor,
All right.
I said that.
I already did. I already said. In fact, Ms. Love said she would recommend that,
Well,
and said that will occur. Correct, Ms. Love?
Yes.
Okay. All right. Anything else, sir?
That's it. That settles everything.
Okay.
Thanks, Judge.
All right. Okay, let me go ahead and call for our jurors. And anything else I need to take up while I got y'all here for tomorrow? All right. So the goal is tomorrow we'll see if we can clear Ms. Bennett, and after that we'll resume with Detective Quinn. Okay, and then we'll see and then I'll give some guidance as to, again, next week, Monday I'll be out. You have an admin day. Tuesday, we'll start off. We'll cover the rest of the motions in limine as it relates to the Baker case that has come out and the convictions and the for Mr. Wise, as well as Mr. Weinstein, are you prepared to take up the motion you filed in regards to the presentation of evidence and your supplemental motion?
Yes, Your Honor.
Okay, all right. Counsels, my goal is if we complete those things on Tuesday, we will not have to come on Wednesday. All right? So but if we don't complete those Tuesday, we'll complete them on Wednesday, and then you'll have admin days on Thursday and Friday of next week. That's where we are at this point in time. All right. Oh, one other thing. Juror, as it pertains to Juror 219 that we talked about before, he has scheduled his appointment. I have a notice from his doctor, which I will mark as the next court exhibit in order and seal. But his appointment is for 16 April at 1:45. So it is my intent for us to work that morning, and then we will conclude to give him enough time, probably 12:30 or thereabouts, because I believe that his doctor, consistent with the last time that we were here, is in Sandy Springs. Okay? So I'll mark that as the next court exhibit. So put that on your radar. The morning of the 16th, we will commence, and we'll probably stop around 12 or 12:30 to allow him to facilitate that doctor's appointment. Thank you, Ms. Weaver. All right, okay. Summon our jurors, please. Chris, it's the 16th, right? 16th? I got it. All right, ladies and gentlemen, please be seated. All right, ladies and gentlemen, given that it's 5:45 and with the consultation of counsel and what I'd like to do is to recess us until tomorrow morning. If I could get you all to be here for 9 o'clock for an anticipated 9:30 start time, we will have a regular work day tomorrow, and that will conclude. And then, as I mentioned to you earlier, your administrative pause week will begin that following week, and then we will see you back on the 8th of April. But we'll cover all that again, I'm sure. Do you have any other ministerial inquiry with me at this point in time? Anyone? Okay. All right, let's go through your admonitions. Remember, don't talk about the case at all. Do not seek any third party resources or persons. Do not talk about the case when you're at home, or let this case be talked about in the presence of third parties. If any third party were to talk with you, of course, you need to let myself and Sergeant Ingram know immediately. Leave your notepads in the basket, and you are not to view anything about the news media about this case or any other blogs or other third-party sites as well. Ladies and gentlemen, and the last thing I'd tell you is, as I've told you and will continue to tell you, thank you for your patience and the attention and the grace that you've given us and will continue to give us. So unless you have any other ministerial inquiry with me, I will see you tomorrow morning. Juror 219, can you remain with us just a second? Okay? All right, ladies and gentlemen, I'll see you in the morning, okay? All rise. Okay, ladies and gentlemen, please be seated. All right. Juror 219, I have your doctor's note. What I'll do that your appointment's on the 16th. What I will do is we'll hold court that morning starting about 9. Okay. We'll recess about 12:15. Should that give you that should give you enough time to meet that 1:45?
That'll be plenty of time.
Okay, that's what we'll do.
Okay.
All right, that's sufficient?
That is.
All right, problem solved. All right, have a good evening, okay? All right, Juror 219 has left us. Anything I need to take up with you all? If not, I'll see you all tomorrow morning, 9 o'clock, for an anticipated 9:30 start time. Ms. Love, you owe me an order, and I'll remain to sign that, okay? We're in recess. I'll see you all in the morning. If you all could turn in your listening devices, please, that'd be great.